The risks don't have to be
You
associated.
think that the Speaker of the House is a flight risk?
The question?
No, this is not your time. This is my time. You think the Speaker of the House is a flight risk? You think he's going to hop on a plane and leave the country?
No, what I was trying to explain is with respect to a non-disclosure order.
He's going to sue about it, so sue this, so who cares? We're going to do it anyways. I mean, you walked all over the Constitution throughout this entire process.
Mr. Chairman, the gentleman's time has
spying
expired.
on members of Congress, and you know it. It's absolutely disgraceful.
Senate and House Republicans have continued releasing documents about subpoenas issued during the Trump investigations, while Chairman Jim Jordan recently referred Smith to the Justice Department for possible prosecution, alleging he made false statements to Congress, an accusation Smith's attorneys deny. Against that backdrop, this House Judiciary Committee exchange became one of the hearing's most intense moments as Representative Brandon Gill confronted Smith over secret subpoenas targeting members of Congress.
Subpoena covered the time period between November of 2020 and January 2021. How many days after Kevin McCarthy was sworn in as Speaker did you subpoena his records?
I don't recall, but those two things had nothing to do with one another.
16 days after becoming the highest-ranking Republican in the House of Representatives, you subpoenaed his toll records. Do you agree that that might reasonably be considered a violation of the Speech or Debate Clause?
I do not, and I want to be clear that the toll
You were
records...
collecting months' worth of phone data on the Republican Speaker of the House, the leader of the opposition, right after he got sworn in as Speaker, all around the time of a major vote. That sounds like a flagrant violation of the Speech or Debate Clause to me, and I think most people agree with me. And Speaker McCarthy had no recourse, did he? Because you issued a non-disclosure order ensuring that neither he nor any of the American people knew about these subpoenas. Is that right?
The toll record, the non-content toll record subpoenas, we did secure non-disclosure orders for those subpoenas.
You did, and let me ask you, Mr. Smith, at the time you secured those non-disclosure orders, was Speaker McCarthy a flight risk?
The non-disclosure order was based on concerns about...
Was Speaker McCarthy a flight risk?
He was not.
He was not. Then why did your non-disclosure order refer to him as a flight risk? It says right here, the court finds reasonable grounds to believe that such disclosure will result in flight from prosecution.
Sir, when securing a non-disclosure order, the risks don't have to be associated...
You think that the Speaker of the House is a flight risk?
The question?
No, this is not your time. This is my time. You think the Speaker of the House is a flight risk? You think he's going to hop on a plane and leave the country?
No, what I was trying to explain is with respect to a non-disclosure order, the risks aren't necessarily associated with the subscriber to the phone. They're the risks to the investigation.
I think that you were using, this was clearly in reference to Speaker McCarthy, and you were using clearly false information to secure a non-disclosure order to hide from Speaker McCarthy and from the American people the fact that you were spying on his toll records. But I've got more, so let's move on. In May of 2020...
But the controversy didn't end here. In July 2026, House Judiciary Committee Chairman Jim Jordan formally referred former Special Counsel Jack Smith to the Department of Justice for possible criminal investigation, alleging that Smith made false statements during earlier congressional testimony about how his office obtained lawmakers' communications. Smith's legal team rejected those allegations, arguing his testimony was accurate and that Republicans were mischaracterizing his answers. Whether that referral leads to further action remains to be seen, but it shows that congressional scrutiny of the investigation continued long after this hearing. Now watch what happens next as the questioning shifts from Speaker McCarthy to multiple U.S. senators.
In 2023, you also issued subpoenas for toll records of 9 U.S. senators and an additional representative. Is that right?
In May of 23, we did issue...
You did, and there were non-disclosure orders in conjunction with those subpoenas as well, right?
That's correct, consistent with department policy and the law.
So again, nobody would know what you were doing. The senators would, and the representatives would, and the American people wouldn't know what you were doing. Is that right?
The toll records that we secured and the non-disclosure orders were consistent with policy and consistent...
And you knew whenever you were doing that there was a risk you were violating the Speech or Debate Clause. Is that right?
The toll record subpoenas that we secured were with the concurrence of the Public Integrity.
Your own analysis says that you knew there was a risk you were violating the speech or debate clause. I have it right here. This is an email from John Keller at Public Integrity Section to your team. As you are aware, quote, as you are aware, there is some litigation risk regarding whether compelled disclosure of toll records of a member's legislative calls violates the speech or debate clause in the D.C. Circuit. That's from your own analysis right there. So you did know, didn't you?
Sir, with respect to the item you just put up on the screen, the last sentence states...
we're going to get to the last sentence.
Okay.
We're going to get to the last sentence. And you cite case law in here, quote, the bar on compelled disclosure is absolute. Is that right? Or do you think that you didn't have to abide by that precedent?
To be clear, this statement is not from my office. This is the statement of the Public
This is
Integrity
your
Section.
Justification for those subpoenas and NDOs that you ordered. This was part of your analysis. It's a cursory analysis. I think it's worth noting. But let's get to that last sentence then. Quote, given my understanding of the low likelihood that any of the members listed below would be charged, the litigation risk should be minimal here. In other words, you're using a novel legal theory, which you knew was novel, has never been tested by any court. You're not charging any of these members. Nobody's going to know about it because you issued NDOs. Nobody's going to sue about it, so who cares? We're going to do it anyways. I mean, you walked all over the Constitution throughout this entire process.
Mr. Chairman, the gentleman's time has
spying
expired.
on members of Congress, and you know it. It's absolutely disgraceful.
Following the January 22, 2026 House Judiciary Committee hearing, congressional oversight of former Special Counsel Jack Smith intensified. Throughout the first half of 2026, House and Senate Republicans continued reviewing internal Justice Department records, subpoenas, and investigative procedures connected to Smith's investigations into former President Donald Trump and his associates. The focus expanded beyond the prosecutions themselves to include how evidence had been collected, particularly involving members of Congress and their communications. The controversy reached another major milestone in July 2026. On July 23rd, House Judiciary Committee Chairman Jim Jordan formally referred Jack Smith to the Department of Justice for a possible criminal investigation, alleging that Smith made false statements to Congress regarding his office's access to communications involving lawmakers. Smith's attorneys strongly denied those allegations, maintaining that his testimony accurately distinguished between obtaining non-content toll records and accessing the contents of communications. As of today, the referral itself does not establish wrongdoing, and the Justice Department has not announced any criminal charges arising from it. Against that backdrop, Representative Brandon Gill built his questioning around one of the Constitution's most important protections for members of Congress, the speech or debate clause. Rather than revisiting the broader Trump investigations, Gill focused on whether federal investigators cross constitutional limits by secretly obtaining phone toll records belonging to senior Republican lawmakers. Gill began with then-Speaker Kevin McCarthy. He highlighted that subpoenas covering McCarthy's phone records were issued shortly after McCarthy became Speaker of the House, and argued that collecting those records while securing non-disclosure orders prevented both Congress and the public from knowing the investigation had taken place. Throughout the exchange, Gill repeatedly suggested that the government's actions may have infringed upon constitutional protections designed to shield legislative activity from executive branch interference. Former Special Counsel Jack Smith rejected that characterization. He acknowledged that non-disclosure orders had been obtained, but maintained that the subpoenas were issued under existing Department of Justice policies and approved through established legal procedures. He also argued that the justifications supporting non-disclosure orders were directed at protecting the integrity of ongoing investigations rather than suggesting that congressional leaders themselves posed a flight risk. The hearing then moved beyond Speaker McCarthy to include subpoenas involving several United States senators and another member of the House. Gill introduced internal Justice Department communications indicating that government attorneys had discussed potential litigation risks surrounding the speech or debate clause before the subpoenas were issued. He argued that those discussions demonstrated prosecutors understood there were unresolved constitutional questions, but proceeded anyway because they believed the subpoenas were unlikely to face judicial review. That became the central disagreement of the exchange. Gill portrayed the internal legal analysis as evidence that prosecutors knowingly adopted an untested legal theory affecting members of Congress. Smith, however, maintained that the investigative steps taken by his office were lawful, consistent with department policy, and reviewed through appropriate legal channels. The hearing, therefore, centered less on what records were collected than on whether the constitutional limits governing investigations of elected lawmakers had been properly respected. It is also important to distinguish between established facts and allegations. During the hearing, Representative Gill argued that constitutional rights had been violated and accused the Special Counsel's office of abusing investigative authority. Jack Smith disputed those claims and defended the legal process followed by his office. Those competing arguments reflect opposing legal interpretations rather than findings made by a court. Questions surrounding the scope of the speech or debate clause remain matters of constitutional law and judicial interpretation, not political opinion alone. Viewed more broadly, this hearing illustrated how congressional oversight had shifted beyond examining criminal investigations themselves towards scrutinizing the investigative methods used by federal prosecutors. As debates over executive authority, congressional privilege, and separation of powers continued throughout 2026, hearings like this became central to broader discussions about the limits of federal investigative power and the constitutional protections afforded to elected officials. What do you think? Should investigators have broad authority to obtain congressional phone records during major criminal investigations, or should stronger constitutional protections limit those investigative tools when members of Congress are involved? Share your perspective respectfully in the comments below.